Kamala Harris is in charge of the Senate that's going to pass the that's going to include the immigration bill, or is it Elizabeth MacDough? We did elected Kamala Harris. I don't see Elizabeth MacDough on the ballot of any of the states, so we're going to discuss about that. We're going to discuss about whether or not do we got the 150,000 extra green cards that were spilled over from the family immigration to the business immigration in this year. What's going to happen with the spillover things? We're going to discuss about that. And yes, we do have very good updates with regards to the travel ban and US visa appointments. We have a court judgment. We're going to discuss and debate about it. And we're going to discuss about the delays in the adjustment of status in Texas Service Center, which has become a nightmare or a black hole, or I don't know what you call it as, a just one-way hell. Seems to be the Texas Service Center. Even Tim Cook, the CEO of the Apple, has to comment on this one. Let's see what they're going to change. We're going to discuss more about that. The million-dollar question is, if your 485 is pending with Texas Service Center in particularly, especially in the downgrade, and now if your EB2 has become current, should you file the 485 application? There are some of them in this, what we're discussing, have no clear answers, guys. So you will see a debate between me and Emily on some of the things, which is better, which is not better. We're going to argue some things. So in that way, we're going to bring all points, not just one side of the point that we're going to give. Emily, when it comes to the Kamala Harris and Elizabeth MacDough, I think so we don't have a difference of opinion. Whom we voted in the election, I guess. Did you vote for, I mean, it doesn't matter whether you voted. Was Elizabeth MacDough on the ballot paper of what you voted?
Yeah, I've never heard of her until just a few weeks ago with this reconciliation bill.
Yeah, so we didn't vote for it. The Constitution is very clear. The head of the Senate is the Vice President. Obviously, the figurehead is Vice President, but when there is a tie, it is not the figurehead, it practically becomes a head, though. The Vice President, especially we have a tie, which is 50-50 votes. I particularly have voted for Biden and Harris thing, but either way, whichever party people have voted, we elected the President of this country along with the Vice President of this country. Where is this Elizabeth MacDough? Why is she controlling the Senate?
Yeah, I mean, she's in charge of the rules of the Senate and making sure they're following their own rules and guidance. But she ultimately doesn't have the power to issue a ruling on this particular topic, or really on any of the topics. She is in charge of the rules and interpreting them, but she can't issue a ruling that they have to follow. Her job is to advise the Senate on what the rules say, how they've been interpreted in the past, how she thinks they should be interpreted, but it's ultimately up to the Senate to decide whether they are going to follow that guidance or not. And ultimately, it is the presiding officer of the Senate, which would be Kamala Harris, the Vice President, when the Senate is in session and she is there. It's the presiding officer who ultimately makes the final ruling, an actual ruling on whether they can proceed or not. So so Harris ultimately does have the power, and as well as the Senate can decide they disagree with Harris if they can get a majority, 51 votes, to go the other way as well. But MacDonough's job is guidance, to advise, but not final say.
It's just like the way we can tell to the Senate too. What difference Elizabeth MacDough has than what I, as a lawyer, can say to the Senate? Does she have any constitutional authority more than what we have? No. What about, does she have any constitutional authority more than the people of the America has?
No, not at all.
Then why is that the Democrats are hiding behind this lady?
Maybe they don't really have the will to get this through.
Well, we request that all of you guys to contact the senators. We have put a draft at the bottom where you can write letters to the congressmen and the senators to get this immigration, though. We know that Plan B has failed. There are a lot of other alternatives that the senators are considering, but I think so we need to bypass the Elizabeth MacDough, because she's always been a deportation lawyer. Emily, for example, or me, we are being trained as immigration lawyers to bring the best and the bright people in the world into this country and have them employed. That's how we are. Some of the people are designed to throw these people out, and she was designed to throw the people out of the country. That's what her job was. Now she's assigned to, she's supposed to give opinions though. As Emily has pointed out, she's not the presiding officer, she's not the judge, she's not appointed by the constitutional authority, she's not been appointed by the president and ratified by the Senate. This is some internal appointment done by the Senate itself. She doesn't have any constitutional rights. Her opinion does not have any constitutional bindings on the Senate to go, so they can. So we would like you guys to write letters to the congressmen and urge them to bypass the Senate, the Elizabeth MacDough, who is the parliamentarian. Parliamentarian doesn't mean the word parliamentarian in the sense of what the common law countries mostly use, like Australia, England, Canada, and India, where we use parliamentarian for the person who properly get elected to the parliament. This person is not even a member of parliament, but he's been called as a parliamentarian. She doesn't have a voting rights in the parliament, still called as a parliamentarian. It just defies the physics though. I mean, it's just doesn't, I don't know what language they use. Why would they use the word parliamentarian when they don't sit in the parliament, they don't have a voting rights in the parliament, they don't have any binding authorities in there. But anyway, we need to override this person's decision and move forward. Democrats cannot hide behind this parliamentarian to not pass the immigration bill. They should pass the immigration bills. If they don't pass it, what's the purpose why we sent them? We give them the presidency, we give them Senate leadership, we give them the House majority, yet they cannot pass it. What's the purpose why they are in power? So they should not be hiding behind Elizabeth MacDough. They have Kamala Harris. They should go with Kamala Harris. She is the head of the Senate. Under all circumstances, we voted for her, and she is in favor of immigration. So we should have, and don't be fearful of voting up and down. Let's see, let's challenge it, let's go to the vote, put it to the vote. That becomes very tough. What Emily, I believe it is that if something can be done, it has to be done by December though. Two reasons. One, this budget reconciliation has only kicked until December 4th. After December 4th, then they have to pass this budget by the time, and our thing has to be included in it. Why it cannot be done next year? In United States, though, for the lower house, which they call it as House of Representatives, the elections happen every 2 years. Unfortunately, that is right. Every 2 years. In most of the other parliament, democratic countries, though, for the lower house, which is also the powerful house in most of the countries, except in the United States, most of the other countries, lower house is the powerful house. And you take that in England, you take that in India, which we call it as, in England we call it as the House of Commons, in India we call it as Lok Sabha. The lower house is the most powerful house, and that's where the Prime Minister comes also. Here, the lower house is not as powerful as in the upper house, which they call here a Senate, and in India they call it as Raj Sabha, and the other countries call different names, but the lower house is a little bit lower powerful. Now they get elected every 2 years. So the election happens in the November of 2022. So if something doesn't get done by this year though, the lower house people, which is also called as a House of Representatives in United States, will have to go election in November of 2022. So what happens is that when any controversial decisions are taken in the election year, they get bitten there. And if they take any decision, the people who don't like it will bite them at the election though. So that's the reason why they do not like to take any decision in the election year, which happens to be 2022. So all those things have to be done in 2021. So we have the budget reconciliation, we have that immigration coming in. So the next 3 months is very crucial for us to keep contacting the congressmen so that so that things can get done. And if it doesn't get done in December though, what are the hopes for us next, Emily?
I don't have much hope after that.
For those people who are waiting for the green card, even if your priority dates, if you're contemplating of filing it, we go back to the old criteria, what Emily has written in 2018, which is 108 years it will take, which was been contradicted by a great institute, by Cato Institute, which says that she's wrong by 48 years. It's not 108, it's 150 years it will take for you to get the green card. Even for those people whose priority dates are not current by October of 2022 though, they may have to wait for 20 years for their dates to become current. So yes, we did estimated priority dates to move forward. We have seen the USCIS, we have seen the State Department wasting 80,000 green cards or so. We'll get the actual figures soon though. And we at least hope so that next year we are going to get the wastage of the green cards very less with the efforts. If they go at the same pace of the green cards what they issued in the month of August, September, and July, August, and September, they may issue the entire 150,000. But if they do wastage though, if your priority date doesn't become current by October of 2022 though, you may have to wait for 10-15 years, especially if you are from India though, for your date to become current, or maybe even 20 years. We don't know, because every year only up to 10,000 people can get the green card, and you know that out of the almost like 80,000 plus green H1Bs issued, 60% of them go to Indian nationals. So you may have to wait for long. Out of these 10,000 green cards, it is for Mr. and Mrs. So it's only 4,000 people will get the green card, actual green card. Rest of the 6,000 people are the family members. So that's a lot of people that cannot get the green card. So it's either by December of 2021 or never. Anything on this, Emily? Emily, on this 150,000 green cards though, where are we right now? What about this Meng amendment, because she wanted to preserve that? Did we already got those 150,000 green cards?
Yes, as of today, those 150,000 extra are there. They're taken into consideration in the October visa bulletin. And decisions on whether to retrogress in November really depend on what happens partially with this potential amendment for the Meng Amendment, which would stop the spillover from happening, or through the reconciliation, which the House version also would stop the spillover from happening, but ensure that the wasted green cards from the prior year were available. So it would go from 150,000 extra to maybe 80,000 extra. I think the biggest problem is I don't expect USCIS to do anything better this year. I think they're on the exact same plan as last year, and we're going to see another 80,000 wasted. That's my prediction.
So definitely the 150,000 green cards are in here. If Charlie was expecting some bill to pass through, at least the State Department was expecting some, it doesn't look like anything is getting through. So there is nothing in the provision that says that this 150,000 extra green cards, or the green cards that are to be given over the 7% cap, has to be given only in the last quarter. There is nothing like that. There is no rule like that. It never existed like that. It was never used like that. So they can give the green cards right now. We should put a lot of pressure on the congressmen and the senators and the USCIS and the State Department to start issuing as many number of green cards, so that the same thing what happened in 2021, which ended on September 30th, does not happen in 2022. We get the 290,000 green cards though. So please contact the congressman. You don't go to the USCIS. My green card, I've applied my adjustment of status, I got my EAD done, I got my I-140 done, can you adjudicate it? They're going to just point out it's 2 years waiting time. So that definitely is not going to work much for you though. It is better to contact the congressman, ombudsman. These are the right people for you to contact. Emily, on the travel ban, we have this court decision though. It says that, now when I read the court decision though, it says that here is a problem where I want to tell the people though. There's a travel ban. The travel ban says that people from certain countries cannot travel to United States unless they quarantine, unless they quarantine in a different country for more than 14 days. Of course, there are exceptions available. Now, our contemplation was, yes, that's fine. We do understand that they cannot travel. Why can't you issue the visas? Now the court decision is saying that, yeah, why can't you issue the visas? Can you explain what the court decision says? What will be the impact when people are applying in the Dropbox and the visas in India and other countries, though?
Yeah, this is definitely a step in the right direction. The court is basically saying that you can't use a travel ban as a reason to deny visa applications or to not process those visa applications. Everybody understands, hey, if I get the visa now with this travel ban, I know I can't travel, but that's no reason to not process the visa. Still give me the visa and I'll wait, or I'll quarantine in another country. I'll follow the travel ban, but just process the visa. That's basically what this court is agreeing with, is saying that you can't use that travel ban as a reason to just not process the visa or deny the visa for those that don't qualify for an NIE. At the same time, the court is not saying that the consulate has to issue the visas for the people that are included in this lawsuit. It's just saying that you can't use the travel ban as a reason to deny the applications. So what does this ultimately mean? I think that all the consulates are still not operating fully, and their resources are limited. They're going to blame the pandemic and COVID and all of that, and they're going to continue to not process visa applications like they used to, but they can't use the travel ban as a reason to deny it or to not process it. They'll just say our resources are limited, we're focusing only on these emergency cases, we'll get to you when we get to you, but they're not going to be able to deny the visa because someone is subject to the travel ban.
Emily, is this court case applicable to everybody, or is it only for the plaintiffs who applied?
Yeah, this one was not a class action. So there were, I think, 180 some odd plaintiffs in the lawsuit, and ultimately it benefits about 9 people who have not yet received the visas yet. But it does not apply to everybody who's in that situation. It's just for those plaintiffs who had not yet received the visa that were included in the lawsuit. But I do think it sets a precedent that the Department of State should no longer be able to use the travel ban as a reason to deny people their visa application.
Yeah, at this point of time, until the things develop, how the things will work though, if you come under the travel ban, I still do not want you to guys make a travel plan. Let's see how this turns out, and we will inform you. Of course, if you come every week, we will update you about all the, this is what we do every week, is that if you come in, we will update you about what's going on. So I would not make any travel plans until it's very clear how the consulate is behaving. Even if you're eligible for the Dropbox, even if you get an appointment with the consulate, though, especially in the countries where the ban is applicable, I would strongly recommend to wait and see. You don't want to be the scapegoat right now, but if you happen to be the scapegoat and you let us know in the comments, then we will try to use yours. And we'll speak with them. And we will have scapegoats, and we don't want you to be the scapegoat, especially the audiences of us. We don't want them. So just hold on your travel plans. Maybe in 2 weeks we will come to know better. If you want to make a booking though, that's fine, but make sure that you should be able to cancel it if you decided not to because of how the things will turning out into. Emily, what about, we got all the rumors saying that in November they're going to lift the entire travel ban.
Well, it's still all rumors. They do seem to be pretty, strong rumors, meaning likely to happen. We just don't know when exactly that is going to happen. But we do still expect that the travel ban should be lifted sometime in December. Most
of the immigration lawyers do agree that the information that came out from a very reliable sources that we can rely upon. And American Immigration Lawyers Association also have very good credible sources which they said they are considering to lift the travel ban in the month of November. That seems to be going on. So if that happens, then we don't have to worry about it. But we will keep you updated on that. Emily, Texas Service Center, a nightmare. for the people. And a lot of people ask the question, is there any chance that if I'm filing an application, can I avoid the Texas Service Center? No, you can't. It is based on your residence where we filed the application. There are 3 lock boxes. Previously, there was only 2, which was Phoenix and Texas. Now we have 3, which is also includes Chicago also. But even when we filed these things though, we don't know where your application is going to end up. Even if you're living in California, even if you're living in Nebraska, doesn't mean that you're going to end up in Nebraska. They will assign the things to a different service center. It so happened that most of the downgrade application assembly ended up in Texas Service Center. What's happening there? Any improvement on there?
Not seeing a lot of improvement on the I-140s or the adjustment of status. I guess more people are reporting that they are finally seeing some success in getting the premium upgrade accepted to the I-140, but the 485, we are still not seeing any cases going through that were filed in October, even when the I-140 is approved and the final action date is current. I'm still getting approvals from cases we filed in 2012 out of the Texas Service Center just this week. Still nothing from cases filed in 2020.
Here is another question that's popping out, Emily. Every single day, we do have a daily conference calls. If somebody wants to come in, please join us. The link of the conference call is there. Every single day, we do dedicate a half an hour for you guys to come and ask the question. And all these engagements, what we do, it's a good improvement for us. It's not only that we tell you what to do, sometimes we understand what you need it much more when we speak with you, when we interact with you. So this daily conference call, if you want to, a link is given to you every single day for half an hour. You can come there, you can ask your question, you'll be answered with the question. Emily, in there, a lot of people are asking me a question. My 485 is pending with this black hole called as Texas Service Center. Should I just, now my filing dates are current. Should I file another application right now? There you go. Abhishek is just asking that question.
Mm-hmm. Yeah, definitely getting that question a lot. So assuming you've continued to maintain your non-immigrant status since you filed last October, you do have that option to file a standalone 485 based on your already approved EB2 I-140, assuming that job offer is still available to you from the employer that sponsored you. So yes, you have that option, but is it the right thing to do? Is it a good option? The downside is, number one, we can't guarantee it's going to go to a different service center. Again, we have 3 different lock boxes where we file it. From there, they decide which service center it ends up at. It could end up at Texas Service Center again. It could end up at the National Benefit Center, which does seem to be processing things on a much better basis, but there's no guarantees. The other thing to be aware of is when you are refiling, you're putting yourself in the back of the line behind everybody who's already pending from last October. So you're basically 12 months behind where you currently are. So it may not ultimately be that beneficial to you. It's certainly a personal judgment call on that. There's no harm in having 2 485s pending as long as all the information is consistent between the 2 and you're eligible for both based on the job offer that you have. But how much benefit will it provide? Probably not much. What do you think?
There's one gentleman who called me today, and I kind of changed my inclination a little bit, Emily. What he said is that, as you pointed out, that I-140 premium processing are getting accepted very much. Yes, I noticed that. His company doesn't want to do premium processing, but his company is okay for him to file the 485 again. In that case, what do you say?
I'd probably go for it in that case. Another situation I came across was someone who actually filed their downgrade I-140 with the 485, not in October, but several months later. So it was just filed a few months ago. They're really not losing out on that much because they haven't been pending for that long yet. So I think maybe in that situation, I would go for EB2 as well.
Yeah, if your I-140 is approved and your final action date is current and I probably am inclining not to file the 485 application for them again. But if the I-140 is not approved, and as you pointed out, recently been, yes, then I would still like you to discuss with a lawyer, independent lawyer, to make sure that you're all fit for. You have to maintain the non-immigrant status. The offer must be there. Employer must be willing to cooperate with you. If all those things, you may consider discussing with your lawyer to see. We are not telling at this point of time, go ahead, do it. No, we're not. But we would recommend that you may consider, though.
I want to discuss some other litigation that a number of you have been asking about regarding a lawsuit in Mississippi, where the judge actually agreed that the delay that people were facing for their 485 processing was unreasonable for those that filed in October of 2020. And that particular judge said that they should be able to have their, I guess, their visas reserved from last year to be able to be processed. And a lot of people are wondering, with our firm doing a lot of litigation, why didn't we do that? Are we going to do that? Are other people successful? That's just one case where people were successful, and that is wonderful for them. We have lots of other cases, not that we have filed, but we monitor
some of them we're involved in too,
all over the place to kind of keep track of what's going on. And our monitoring of those cases, there are many where the judge deferred to USCIS. It's your job to decide how you want to process these visas and how quickly you can do it. They blame COVID. The judge agreed COVID's a problem. And so they came the complete opposite and said, no, the judge has no power in order to force the USCIS to reserve those visas or grant the adjustment of status. So the majority of cases come out the other way. This particular one, the plaintiffs were definitely lucky, and that's wonderful for them. Will I go out and start filing a ton of lawsuits for people that have been pending for a long time? I think it really needs to be in very specific circumstances where there's some kind of error that USCIS has done, or there's a child aging out. There's got to be more aggravating factors, and even with that, there's just no guarantees. It completely depends on the judge and the court that you end up in, which you don't have a ton of control over. I mean, there are many that are not as immigrant friendly that we've come across.
I just want to explain you how the system works in the court system in the United States, guys. For any action on the USCIS, for example, it can only be filed in the federal courts. Federal courts have three levels. One is the district court, one is the circuit court, and of course the Supreme Court. So the district court, there are many circuit courts. So some of the circuit courts already ruled that the USCIS, the judges don't have the discretion though. So we need to study about. So it is very unlikely that if we file a litigation broad for all the people, we are going to get success, just like what happened in this particular Mississippi case, though, because a couple of circuit courts have already ruled that we don't have the jurisdiction. But as Emily pointed out, yes, we are taking court litigations, and they have to be a little bit more unique than the normal people. Oh, like Emily has pointed out, if the child is aging out, sometimes one of the person of the family has got it, the other person did not get it. There must be some unique cases though. So if you want to, you can consult our office. The best lawyer for that in our office is Stephen Brown in our office. If you go to the appointments, you can check his schedule, and you can make an appointment with him to discuss if you would be fitting into that particular criteria to file a court case.
All right, let's get to other questions. Simbu from YouTube says, my wife's H4 EAD will expire in 2023. If I move to a different company and they file a new H1B for me, will it impact her EAD? Can she keep working while I get the new H1 and H4 approved? So a transfer does not impact an already approved H4 EAD as long as you are considered to be in H1B status based on the pending transfer, and then once it's approved, that she's considered to be in H4 status and can use that EAD. The only thing to keep in mind is once you do transfer, your end date for your H1 may be different. It may be extended further than what her EAD validity is. So just keep that in mind so you don't miss filing her renewal in the future.
Murli has this question. His I-140 has been approved. He priority date has been put as 2020, but it should have been actually 2014. Can he use that to file the 485? Yes, Murli, we have done that several times. And what we do is that when we file it, we provide them the previous I-140 approval. We explain them. We put a color sheet. My colleague prints out with funny character color sheet. She prints it out, and we put it out there saying that do not reject. The priority date is 2000, whatever it is, not 2020. Please see it. Do not reject. If you want to reject, take this to the supervisor. We put some funny characters there, and we put those things. That's how, when the officer gets into it, looks into it, oh, 2020, born in India, I'm going to reject this one. But when he sees that a lawyer has already put some funny color sheet saying that, hey, there is something wrong in this one. He already knew that there is something wrong in this application. He's telling me that, look carefully, there is something different. They normally don't reject it. They will take it to a supervisor. They will consider it. This happens many times. We do that. Many lawyers do it. It's not that uncommon, but we do it whenever there is any odd thing that goes on, like yours. Sometimes what happens is that the main applicant is from India and the wife is born in United Arab Emirates. Even though she has an Indian passport, they consider as cross-country chargeability. We do the same thing. We put a color sheet. Look, the spouse is born in UAE. Here is the birth certificate. Don't reject it, take it to scenario. There are a couple of other scenarios where we see anything odd about it. We have to point out to the officer that it's odd, and it goes through normally very good.
Rod says, my date is current. I-140 is approved in March with the premium processing for a downgrade, biometrics done, medical interfiled. Is there anything that I can do? Should I apply for a 485J so that the officer can look into my case? Good question. At this point, you've done everything that you need to do. Your case just needs to be processed in the normal processing time. I don't see submitting a supplement J as helping to get the cases processed. It doesn't mean that they're going to grab your file off a shelf and give it to the officer and say, hey, look at this right now because this person submitted a supplement J. They just stick that in the file and it just stays in line until an officer actually gets to the case. So I don't think there's anything more you can do other than just keep an eye on it and be ready to respond in the event of any type of RFE.
My place of birth is different on my passport than the birth certificate. Will that issue on a 485 application? Rajan Patel from YouTube asked this question. Rajan, we have noticed very minimal, in fact, approximately around 15 to 20% of the time, the place of birth on the passport is wrong for Indian nationals. We haven't seen much RFEs because of the passport birth city is different than that of the birth certificate, though. We haven't seen much RFEs. If it happens, we can always explain them, telling that the passport may not have the correct information there.
Number of people have been asking for any updates on H4 EAD premium processing. No news at all on that. We have no idea if they're planning to implement it soon, other than the same that we've had before, that we know that it's in the unified agenda to implement it, but no idea when.
Krishna Kumar has this question. Can we file multiple 485? One wife as a main applicant, one I as a main applicant, and my wife as a dependent, vice versa? Absolutely, you can. Nothing wrong with that. Abhishek has this question. Is there a chance, Abhishek Thakur from Facebook has this question, is there a chance EB2 filing dates might move to December 2012? According to the estimate, though, EB2s are expected to move. Since there was some expectation that there may not be a spillover from family immigration to the employment-based immigration. Now that seems to be gone right now, so we may expect the things to move more forward in EB2, especially in the coming November and December visa bulletin. We are expecting them to move.
Prasad from YouTube says, what happens to my 485 EAD application if I travel outside the country for a vacation? Nothing at all. That application can continue to be processed, so the travel has no impact on a pending EAD.
From Chicago's lockbox, which service center with the 485, straight 485 will be sent to? Good chance that it may not end up in Texas Service Center, but no guarantees, guys, no guarantees. It could, there are some times. But good chance, if it's a straight application, it may end up in National Benefit Center. I don't recall any I-140 file with 485 ending in National Benefit Center, though. Maybe I would say that not many, I may correct myself though, not many I-140 and 485 together applications end up in National Benefit Center, which is actually the best place. So sometimes it may be best to file an I-140 and file a 485, but that's up to you guys, because what if the prior date goes back? Then what will you do at that point of time? Definitely you may want to evaluate that option if you want to.
Zimchrist from YouTube says, if a congressperson is ready to help with my green card application, would working with them impact my case negatively in any way from USCIS point of view? No, not at all. You absolutely have a right to ask your congressman or senator for assistance with a federal government agency. It does not have any negative impact on your case.
Do you think the president can sign a presidential to get the bills passed? No. Ashwini Patel has this question. The president cannot interfere into the legislative manner with a presidential proclamation saying that you get the bills passed. That can only happen in a dictatorial things, not in United States, not in any of the democratic countries that I know about. No, the president cannot issue a president proclamation though. However though, Ashwin, you did point out very good things though. If the Congress does not pass the bill, Emily, what would the president do?
I think he is, based on his experience with DACA, I think he's likely to move ahead with some sort of executive order or changes to the regulations or how they interpret the laws that Congress has passed in order to make some improvements. Can he do things that only Congress can do? Definitely not. But I do think he would go forward on his own. So
let's think of this thing though. The Congress is dead right now, Emily. So what all the things that the president can do, according to my reading of the law, is that he cannot increase the number of green cards. That's for sure. That is given to the employment based. But can he allow the people who have I-140 approval for more than 2 years file a 485 application?
I think that might be
a
stretch.
Because why?
Well, because the INA specifically says a visa must be immediately available in order to
file the 485.
485.
Okay.
Now, could he provide some other alternative, like an EAD? Maybe.
Yeah. Could he provide a EAD? Can he provide the changing of the employer from company A to company B without going through the H1B? Yes. It may not be the 485, but it can be some intermediary between the 485. So he could he could allow the people who have I-140 approved to apply for an EAD and give them the EAD and move from company A to company B just on the EAD itself. Just like the way what the DACA people do. So that can be done. The second thing that I'm thinking about is that can he issue regulations to use the unused green cards from 1992 to right now? Because Congress passed, the USCIS and the State Department has to use up those things. These dummy guys didn't use it, okay, especially the 80,000. So can he pass a regulation? Can his administration pass a regulation to get this 300,000 green cards into it?
I don't see anything in the statute that says no. Would it ultimately stand up? Because there would be a lawsuit on it.
There'll be a lawsuit, of course.
Would that stand up in court? I don't know, because they might say the executive doesn't have the power to do that.
Well, the executive have a power to issue the temporary protected services for people from Honduras, from Nepal. He have given employment authorization to them. He has given employment authorization to the entire more than approximately 1 million people who came under when they're 15. He has an authority to.
H4 EAD.
H4EAD, that came in the regulation by itself. Yep, the H4EAD came by regulation. L2EAD is a different, H4EAD came by regulation. Yeah, he can. The other thing that I'm also possibly thinking about is, Emily, how about not counting the family members?
I think that's a great one, because the way the statute is written, in my mind, it does not say you count the family members. It says that on the family-based side, which is a different section, the wording is different between the two. And the way they worded the employment-based, the statute does not say that family members are counted.
So at this point of time, we can, if the Congress fails though, we can request the administration to do a couple of things. One, to not count the family members, to look into the aspects of issuing an EAD for the people whose I-140 has been approved, so that they are not stuck with the H1B, and also look into other avenues to give better methods for the people to have flexibility in the employment, because flexibility in the employment is very absolutely needed, because people are locked with one employer and they want to move from one employer to another employer. There's a lot of expenditures, there's a lot of legal expenditure, there's a lot of time process, there is inclined letter, and these regulations keep on changing very frequently. If they get to a stage of adjustment of status, or to even allow to get an EAD, just like the way DACA kids, every time they renew a DACA EAD, the renewal is not that expensive. They're doing by themselves, it's more easier. So if that provision is given to the I-140 people, we may be. So we will keep watching us. We will try to draft those things in the coming. At this point of time, our focus will definitely be to have the things passed in the Congress. And if that doesn't work though, which I'm thinking the deadline is December 31st. After that, it's going to be election year, nothing's going to happen. Only president can pass, only the administration can pass these president proclamations or the regulations. We should strive to get those things if we can't get the Congress work on it.
Let's see, a couple of people asked for updates on the EAD litigation. So we have kind of two different things going on with H4 and L2 EAD lawsuits. We have the class action lawsuit, and then we have a second lawsuit that was filed to basically request automatic extensions be provided for both L2 and H4 EAD applicants who are renewing their EADs. Both of those, I don't have any updates for you. The second one, usually the government has 60 days to respond, and I don't think any response has happened yet, so we're just waiting on that. On the class action lawsuit, I think that's tied to the potential premium processing, so we may not see movement on that until we know what's happening with the premium processing option.
Viru has this question from YouTube that he wrote letters to North Carolina Republican Senator, but no progress. Viru, it's okay. We are immigrants. We want our things to be getting done, irrespective whether the senator is a Republican, whether the senator is a Democrat. We request everybody to write the letters, though. Even if they have a hard stance against immigration, it may soften them when you write the letters to it. Will they come and bite you if you are in their constituency? No, they won't. Believe me, they won't. We've never seen the circumstances. And they don't have an authority either that they will come and bite you. You're not doing anything illegal. So you have an authority to write. You should write it. To petition to the Congress is a hard end thing. Many people have died just to have the right to petition to the Congress. You all guys have it, even if you're a US citizen or not. You can write to letters. Of course, you should never mention that you are a US citizen. You can clearly mention you are an H1B, you are in whatever visa status. That's perfectly very good to mention them. If you are living in their constituency, keep writing letters to them.
Rohit had a question about whether these videos are available to watch later on. Absolutely. We do have actually an entire video gallery on our website at rnlawgroup.com where you can access them. They're also available on our YouTube channel. If you go to YouTube and search for Reddy and Neumann, you'll find all of our videos there. And another question, Pandu wanted to know, is it possible to change employers on an H1B without having the I-140 approval copy when you're trying to extend beyond the 6-year limit? And one of our viewers did answer his question that you can get that I-140 approval. You can't get the approval notice, but you can get the copy of the I-140 petition. The front page will say it's approved by doing a Freedom of Information Act request, but you can go ahead with filing of the H-1B transfer without having that and ask USCIS to look that up. And they will find it in their records and verify.
Emily, I want to debate with you on some of the aspects that what we told before and what we are going to change right now. Nikhil Choradia has this question. Now the priority dates are not moving forward. Would you switch the job? If your priority date falls, let's say, for example, in January of 2015 to 2018.
Good question. I would choose the new job carefully, because the labor certification process is not as fast as it used to be. The prevailing wage is still taking 6 months to process. So if you're going to be changing jobs, as part of that negotiations, make sure that they will start that labor certification process for you as soon as you join, or see if they already have a prevailing wage that's granted or in process, so that'll save you a little bit of time and they can proceed with the filing of the labor certification faster.
I will also consider, Emily, with regards to, I want to answer Naveen more carefully, Nikhil more carefully, is that is my priority date in 2015 or is it 2018? That makes a lot of difference. If it is 2018, yeah, definitely. I still will consider what Emily has said before I move. I will also look into the geographical location where I want to settle to. I will also look into the salary differences to see, evaluate myself. Is it good? Is it not good? There are some important information that I want to point out, guys. There is something called myvisajobs.com. If you don't know what that site is, please, myvisajobs.com. Whenever you join the company, though, you can look into the salaries, what they are paying, the green cards that they are filing, the H1 they are filing, the degrees what people have it, the nationalities that they have it. You can even see how many people from your particular university have gone in there, and you can get all the information there and see how active their company is filing the H1Bs, is company filing the green card applications. Though, as Emily pointed out, that are they going to do it right now, or are they going to do it later on, will definitely influence in my joining that particular company, though. Geographical location, obviously, each person will have their own particular preference. Salary, of course, that's something has to be considered too. So yeah, all those things, I am a little bit flexible right now. And I may be negotiating more right now, but maybe wanting to switch in January by the time things will be more clear. But I will consider myself that if it's 2017, 2018, I may now want to consider moving to a different company if they have a better opportunity, if they're willing to file the green card application immediately.
Srilatha says, can I relocate and work remotely for the same employer in the same position before filing the I-485 application? I think it depends. How that would impact the green card is based on whether this move is permanent or temporary. So if the job offer at the original location remains available and you intend to go back to work at the original job offer location when you get the green card, then you can do that and your green card can continue. The process can continue even if you've not filed the 485 yet. But if your position is going to be completely remote, you're never going back to the office, and the work location is in a different area, a different metropolitan area, then that labor certification that was filed in the other metropolitan area may not be valid for your new work location. You may have to file a perm again.
So Emily, but it's just the intention that counts, is it right? Even if, let's say, for example, I'm working in Alaska, but my job is in Texas, and I intend to move, and my company intend to take me, that intent, isn't that enough to file the 485?
Yes, absolutely.
Is it, Ajaya Anand has this question, is it safe to move jobs after the I-140 is approved? I'm assuming, Mr. Ajaya, that you're speaking about you're filing the 485 application and your I-140 is approved, and it's been more than 6 months that your I-485 has been filed. Yes, if I were you, I will definitely move. This statement I've been making all along, though. With regards to moving the job before filing the 485, I may have changed my opinion recently, but with regards to changing the jobs after 180 days, yes. The question that comes from Sanfax is the same line. I-140 approved, EB3 downgrade, EAD is not yet approved, but he has filed as a adjustment of status in October 2002. Can I switch it up? Yes, you can. The only thing that you have to do is that other than you have to file a H1B also. We strongly recommend to file the 485J supplement too, obviously, but you have to file a H1B. Without filing H1B, you cannot move jobs. Yeah, it is definitely safe. Your 485 will continue as long as your company is willing to file a 485J supplement, which is also, some people call it as AC21, not a problem.
Asim wants to know, do we need the I-140 approval before the H4 EAD can be applied? There's two different ways to qualify for the H4 EAD. One of them is if you've gotten a 7th year extension of your H1B, even without having your I-140 approved because your labor was pending for 365 days, then that makes your spouse eligible for the H4 EAD. But if that's not the case, then you have to wait for the actual approval to file the EAD application. Otherwise, you're just going to get an RFE that's going to delay the EAD an extra 2 months or longer.
Manoj has this question. My child age is locked in final action date because I-140 is approved. If he changes, is a good question, Emily, that I want you to pay attention. So he got I-140 approved, obviously pending for a long time. The child age got locked out. Now, can he switch back to EB2? You may have to consult a lawyer, though. Here is the thing we are concerned about is that, is it right, Emily? I'm thinking, contradictory, we're just debating. Because the rule says that your I-140, the underlying I-140 is the one that locks your son's age, though. So if your I-140 for EB2 has not been pending for a long period of time, that may affect the age locking thing completely. So before you switch back to EB2, though, don't consult a lawyer. Make sure all the numbers match. If not, don't move to EB2. You're better off staying in EB3.
San wants to know, I filed the AOS in October 2020, I-140 is approved, but no EAD yet. Can I switch jobs? Potentially. So once the 485 has been pending for at least 180 days, you do qualify for AC21, so you can take your green card process with you to the new employer, but you need a way to work for them lawfully. Since you don't have the EAD yet, that means you would have to file an H1 transfer, assuming you're on H1B status still. So if you're no longer on your underlying non-immigrant status, then you need to wait for the EAD.
One question is that, can Naveen from Facebook has this question, can main employer A and concurrent employer B both file GCs at the same time? Can I choose whoever becomes first, whoever comes first? You're assuming that the POM becomes, absolutely. You can choose one, you can choose two, whoever you want to. You're not restricted to choose the first one and let the other go. You can taste the apple and you can taste the mango too. Absolutely, you can eat both the things.
Manoj has an interesting question. My wife filed 485 with her as the primary and me as the derivative, and our date is current in the final action date. If I do an H1B transfer now, am I eligible for 3 years or only 1 year? So you probably know that once your final action date is current, you're not eligible to keep getting those 3-year extensions under AC21 beyond the 6-year limit because it's expected that you'll receive the green card. But in your situation, they would be looking at your I-140. Is that final action date current? Sounds like it isn't, so you should be able to use your own I-140 to extend for 3 years, even though you have a 485 pending based on your spouse.
Question from Preeti Yadav, USA Vlogs has this question. Do you prefer EB2 and EB3? Explain. I still prefer, now here's the thing, Preeti, though. When filing the labor certification, I would definitely prefer EB2. Why? Because if I have EB2, I can use the same labor certification to file EB2 or EB3. Or I can file both. But if I file the labor certification EB3, though, I cannot file using that labor certification for EB2. So that's the reason when it comes to the labor certification, it's EB2. Now, when it comes to the EB2 or EB3 in filing an I-140, if I were in your position, Preeti, I would give a coin to my spouse and tell her to spin. And if it, whatever she tells, I will file, and if something goes wrong, I'll blame her. I don't have a better method. Obviously, Preeti, I would prefer to have both options available, EB2 and EB3. So once the labor certification comes in, I will go for both. If the employer doesn't give an option of both, we'll say that only when it becomes current, I will give the coin to my spouse and tell her to pick it. And something goes wrong, don't blame me, blame your wife or your husband.
All right, well, I think we're out of time for today. Thank you so much for joining us. Remember, you can always sign up for our newsletter at rnlawgroup.com. We send that out every Wednesday morning, so you can get the latest updates and all of our articles on our website. Make sure that you subscribe to our YouTube channel if you're watching there, or on Facebook. Subscribe so you get notifications of when we're going live.
Thank you.